offering that from the actual amendment language to add Section A at the beginning of that amendment, which stipulates, in order to provide for the fair and effective representation of the citizens of Ohio, there is hereby created the Ohio Citizens Independent Redistricting Commission, which shall meet and establish in the manner prescribed in the article the boundaries for each of Ohio's state legislative and congressional districts.
Okay, we've had a motion and a second in the description of the amendment. Is there any discussion? Senator Faber.
Thank you, Mr. Chairman. I'm confused. This appears to be an amendment from another section of the entire text of the constitutional amendment, not the section that's being proposed. And the Supreme Court issued its order basically saying that we do not include this in the listing, and now we're going to open up other areas to discuss beyond the three from the court. And in one, I would argue that, frankly, that this area is outside the scope of the things that we're here today to fix or to adjust, and therefore, frankly, I would move the lady amendment on the table.
Mr. Griffin.
Thank you, Mr. Secretary. I believe that the section is within the Supreme Court's mandate. It has asked us to provide proper language for the constitutional amendment. It's instructed us to identify the substance. I think paragraph A does. And as we're discussing whether or not to put in the actual language or not, it's clearly consistent within that. I also want to clarify what the Supreme Court told us to do, that the ballot need not contain the full text nor a condensed text of the proposal. So we're not required to do either of those, but our commitment is to explain to voters what they are voting on. And paragraph A does that. It is within our mandate here today. And I think that in that addition, I think the rest of this is workable.
Mr. Secretary.
Mr. Strayhorn.
I would add to that, as I stated before, in terms of our minimum requirement and having a higher threshold to try to provide clarity. I think as voters go to the ballot or receive these ballots in the absentee ballot form, that is a more succinct way of explaining what this amendment is, or what this ballot initiative is designed to do, which is to establish boundaries for each of Ohio state legislative and congressional districts, and what has been formed to create that. So I think while it may exceed the minimum standard, I think the greater goal that we should have in providing clarity for the voters, I think, since we can't do these other things, since that seems to be more complicated, I think that being the initial thing that voters have an opportunity to take a look at does clue them on exactly what's at stake. So thank you.
Any additional comment? Senator Faber.
Just briefly, Mr. Secretary, again, I go back to the issue here. If we're going to start cherry-picking other areas beyond the court's edict on the three areas the court told us to come back and clarify, then frankly we ought to probably just print the entire amendment on the ballot, which would be 8 pages. And the court said we can use the whole thing instead of the shortened version. I don't know that this paragraph 8 tells us anything about this text. First, it calls it an Ohio Citizens Independent Redistricting Commission. It is not independent. It includes partisans from both parties. Citizens. There is a large list of citizens who are excluded from inclusion. And so I would argue that this alone, without the rest of the text, would actually be more misleading. But having said that, if we want to include a section beyond the sections that the court had us deal with, certainly there are other sections that we can include as well, including all of the provisions that are in the proposed constitutional amendment, deleting all the other provisions of the Constitution that exist now. But again, we're now dealing with the space constraint, and we would have a very, very long set of language on the ballot. So again, Mr. Secretary, I don't support this amendment.
Mr. Secretary, I'd like to respond to that.
Mr. Strayhorn.
Thank you, Mr. Secretary. The fact of the matter is, the language has already been cherry-picked because it did pick out, the staff prepared did pick out the elements that they wanted to pick out. What we're saying in concession to really take into account account what the Secretary has said, and to print the entire ballot language would be almost cost prohibitive for the Secretary of State's office to put this undue financial burden on county boards of elections to print these ballots out. I think to ask for one paragraph to add to it that comes precisely from the amendment language is not too much to ask, and is a fair compromise also to concede that we don't want to make the language so lengthy that it creates this undue financial burden. I think that's a reasonable expectation.
Any further comment? Okay, we have a motion in a second. I would ask that the Secretary call the roll on Mr. Strayhorn's motion to amend.
Senator Favor?
No.
Mr. Morgan?
No.
Mr. Griffin?
Yes.
Mr. Strayhorn?
Yes.
And Secretary Husted?
No. Okay. Are there any additional amendments?
Mr. Secretary, Mr. Secretary, I want an additional amendment.
Mr. Strayhorn.
The amendment is to substitute for what we have in the staff prepared ballot language for section 2, where it says where it starts create a state funded, and ask that we substitute the entire section number 2 with a portion of the third paragraph from the Supreme Court decision, page 2, in the facts section related to proposed amendment, to read as follows. The proposed amendment would establish the Ohio Citizens Independent Redistricting Commission consisting of 12 members to be chosen as follows. First, eligible persons would apply to the Secretary of State for membership on the Commission. The Chief Justice of the Supreme Court would select by lot a panel of 8 Court of Appeals judges, no more than 4 of whom may be of the same political party. The panel would choose 42 persons from the applicants eligible for membership on the Commission, consisting of 3 different 14-person pools, 2 from each of the 2 largest political parties and 1 from neither party. The Speaker of the Ohio House of Representatives and the highest ranking member of the House who is not of the same political party as the Speaker would then be permitted to eliminate up to 3 persons from each of the 3 pools before the panel of judges selects 9 commission members by lot. These 9 members will then select from the remaining pool 3 more members for a total of 12.
I would second that motion.
We have a motion and a second. Is there any comment on the amendment? Senator Favor.
Thank you, Mr. Secretary. I would oppose the amendment for several reasons. First, I'm a little confused. First, we wanted more, now we want less. And we just heard a second ago that if we accepted the initial conclusory statement, that would be fine with the rest of the amendments. And we didn't accept that conclusory statement, so I guess that's why we're coming to try and amend the rest of the amendments. But from that perspective, I think it's important now what you're trying to do is, again, summarize the existing ballot language. And by summarizing the existing constitutional amendment, by very nature, you are picking and choosing which material facts you choose to omit. And one of the things that is not in this, if you read this through, are the other provisions that are contained in sections A through F. Like, frankly, the fact that the commission members aren't subject to removal by the General Assembly or any member of the executive branch. Like other topics that are reflected in those paragraphs. So again, now I'm questioning whether or not by failing to adequately summarize this, you're making material omissions that opens it up to criticism from the Supreme Court. And remember, we tried to do this in a simple summary paragraph that the realtors in the Supreme Court case challenged as not being inclusive enough. And I know of no way to be more inclusive than to print the actual language that's proposed, that's presented here as to how these members are selected and how the commission members will operate in the selection process. So for that reason, I oppose the proposed amendment and would ask that we call the roll.
Mr. Strayhorn.
I would just like to respond to the commentary and to, with all due respect to the Senator, try to alleviate some confusion. I'm not fixated on the size as much of this as I am clarity. So if it seems like it jumps around, it's because I'm not focused on whether the ballot language necessarily is smaller or longer, even though I know that that can create confusion. I attempted to get something that was from the amendment language that would have kept us shorter, and I think given some additional clarity to voters as they began to try to make a decision. In the absence of that, I'm still striving to see if we can't get some clarity, and I believe that adding that paraphrasing language as opposed to a lot of the legalese language there would help to provide more clarity. I can't predict whether the Supreme Court would say that there's material information missing from that or not, although it is my opinion that I think it would suffice.
Thank you, Mr. Strahan. I sympathize with what you're trying to accomplish here, but let's not be confused. The legalese here is the actual language from the amendment. So my hope was that we could come to some sort of consensus here on this. But I am, with my responsibilities to make sure that we can push forward to ensure that this gets to the local boards in time, that they can transmit the ballots in compliance with federal law. I am hesitant to do less rather than more when it comes to complying with the court's order. And I recognize that there is that what comes with this is the potential that we are doing more than necessary. But my fear is that in not doing enough to fulfill the court's request, that the administration of the election could be jeopardized. Mr. Griffin.
Mr. Secretary, and I share your concern that we need to comply with the Ohio Supreme Court's instructions to us, which is why taking and quoting language directly from the Supreme Court's understanding of what this amendment would do, I think solves and resolves that. It is also shorter to the extent that we're concerned about cost for the taxpayer and the Board of Elections. It is more concise, but I think most importantly, it's written in plain English, and the legalese, in fact, is taken directly from the proposed amendment. Paragraph 2A in the summary language is simply a copy and paste from paragraph 3, and then that goes through paragraph 8 of the actual language of the amendment. You shouldn't have to have 3 years of law school, a law degree, having passed the bar in order to understand what you're voting on. And I think the Ohio Supreme Court has set forth that language for us. It clearly is neutral, is not partisan, and I think Mr. Strayhorn's amendment is appropriate.
Okay. Any more comment? Secretary, would you call the roll on the amendment?
Senator Faber?
No.
Mr. Morgan? Mr. Griffin?
Yes.
Mr. Strayhorn?
Yes.
And Secretary Husted?
No.